Sunday is International Tea Day, and when South Africans think about tea, the first thing that comes to mind is probably Rooibos. However, the Rooibos industry continues to fight to keep the beloved tea proudly South African. This as the South African government attempts to trademark Rooibos in the European Union to counteract a French company's attempt to trademark the name Rooibos. To discuss the trademark as well as what it means for South Africa's Rooibos producers, we joined on the line now by Professor Owen Dean, Chair of Intellectual Property Law at Stellenbosch University. Prof, could you paint a picture for us perhaps as to how far we are regarding the trademark saga for Rooibos?
Well, Rooibos is not strictly speaking a trademark. It is what is referred to as a geographical indication. Namely, it is a mark which suggests that a product comes from a particular area and that its characteristics are influenced by the area from which it comes. Now, it has happened more than once in the past that attempts have been made to register Rooibos as a trademark. Now, there was a brand name in various countries. The first attempt happened in America, and currently or recently it occurred in France, where a local trader attempted to secure a monopoly over the use of the brand Rooibos in that country, and more particularly in the entire European Union. Now, until fairly recently, our government and the Rooibos producers had done very little to protect Rooibos as a trademark, or as more correctly a geographical indication. But happily, steps were taken recently, and the Minister of Trade and Industry published a notice under the Merchandise Marks Act, in terms of which a particular mark or the use of a mark can be prohibited unless it is used subject to certain conditions. And the conditions that were imposed in the case of Rooibos was that the mark had to be applied to the product coming from the Cederberg area, the product that we know as Rooibos. Now, the significance of local protection is that, well, apart from the fact that it protects the term in South Africa, if you want a term like that to be protected internationally, you have to first protect it in your home country. Only if it's protected in your home country will other countries be prepared to regard it as a geographical indication. So it was very significant and very important that South Africa should take some steps to protect Rooibos locally. As I've said, happily that has now been done, and the European Union is now taking up the issue and will, one expects, very shortly recognize Rooibos as a South African geographical indication, and therefore prevent others from using it or attempting to monopolize it in France or in Europe, unless it is used in relation to the genuine product coming out of South Africa.
Oh, and I understand that this battle has been going on for about 8 years. What has been the delay?
It's a very good question, and I'm not sure I know the answer. I think it's just been sort of really indifference and lack of getting our act together, because the writing was on the wall 10 years ago when this problem occurred in America. And I and others mentioned or recommended to the government that they should take appropriate steps, in particular under this Merchandise Marks Act. And they sat back and did nothing. Now, quite why that happened, I don't know, but I suspect it was just a question of inertia.
Oh, and just to close off with, does this potentially send a precedent regarding intellectual property in South Africa? Well,
it has, because, Rooibos is but one of probably several geographical indications that we have, and which one would want to have protected internationally. I mean, there's a worldwide move to protect geographical indications, things like champagne denoting a particular product out of France, and sherry as a product coming out of Spain, etc. And we've been lagging behind the rest of the world. The rest of the world has been jumping on the bandwagon and getting their geographical indications protected. But until these steps have been taken with Rooibos, we in South Africa have done nothing. But we've only done it so far in relation to Rooibos and honeybush, and we need to look at all the other geographical indications that need to be protected.
Well, Professor Owen Dean there, thank you so much for your time. He is the Chair of Intellectual Property Law at Stellenbosch University.